Do you need an estate plan? You know, I like to say if you own something and you love somebody, you need an estate plan. And there are certain legal documents you need to have in place. And these legal documents take care of you while you're alive, and then take care of your stuff and the people you love when you're gone. And so there are several key documents you need to have, and there are mistakes people make. So we'll just kind of hit a broad overview of that. So the first is, of course, you need a will. Now, the will just says who gets your stuff when you pass away. The will is an at-death document. It means nothing until the day that you pass away. The biggest mistake I see is not keeping it up to date. Every few years, I would say every 4 or 5 years, you need to be getting out your legal documents and reviewing them, checking with your attorney to see is there anything you need to update. You know, maybe there was a Tennessee statute that changed. Or if you have a major life event in your family, which would be a marriage, a divorce, a birth, or a death, you need to get out your legal documents and review them. That's the biggest mistake that I see. The second would be not having a fallback executor. You know, your executor is the person in charge of administering your estate when you're gone. Well, maybe you name your spouse, but then you've got 3 kids you didn't know who to name. Or maybe you're not married, you have a child, you only have one child, so you name that child. Well, if your executor cannot perform that function, who's going to be the executor? You need to always have a fallback there. Now then, the second set of documents would be your powers of attorney. There is a medical power of attorney and there's a financial. The medical is for someone to make your medical decisions when you cannot. The financial is for someone to pay your bills and administer your affairs when you cannot. Now, you could be temporarily incapacitated, but you've got to have these documents if you want things taken care of efficiently. And these take care of you while you're alive. So they're critically important. And I would say the same thing I said on the executor, which is make sure you have a fallback. If your power of attorney cannot serve, who's going to be the power of attorney? Now then, there's also a living will document, which is not a will. It's just it's an advanced medical directive. I like to call it death with dignity. You're incapacitated. You have no hope for recovery. How do you want to pass on? More and more, you know, if you have a properly executed medical power of attorney, you don't have to have a living will. What I have found is as people age and get into retirement, more and more people like having that living will because you're putting your instructions in writing, and what that does is it takes the burden of the decision off of your child's shoulders. They're not having to make the decision. I mean, your daughter may know what you want, but she's still having to tell the doctor, pull the plug. Okay, and that's a difficult decision. Whereas if they have a piece of paper that says what you want in writing, then they're just saying, hey, here's what mom wanted, so here's what we're going to do. So that, you know, that's, I think as you age, more and more people do that. Now then, do you need a living trust? You know, a lot of people will do a living trust, and when you put things in the living trust, the trust document that then governs who gets what rather than the will. And the number one reason people do a living trust is to bypass probate. Now, for most of your assets, you don't actually need a trust to bypass probate. All your investment and bank accounts can be structured where you name a beneficiary and it avoids probate and goes directly to beneficiaries. But you cannot get real property to your kids, your house, any other real estate you have especially. You cannot get that to your kids without probate, without a living trust. You know, probate in Tennessee is a pretty simple process. So there is value to having a living trust. But if you don't have a lot of assets and a lot of risk exposure, there aren't a lot of reasons to necessarily pay $2,000 or $3,000 to get a living trust. Now, there are a couple of big reasons you would want to consider it. One would be if you have property in multiple states. You know, you have a condo at at the beach in South Carolina. You might want to have that in a trust so that your kids don't have to probate in both states. And then if you're going to do that, might as well probably put the Tennessee house in the trust too. So property in multiple states would be a great reason. The other thing is if you have a high net worth, there is more flexibility with late in life planning as the estate laws potentially change if you have properly drafted trusts and powers of attorney. Can't get into that detail today, But all of these topics, these are things you need to be thinking about and speaking with your advisors and coordinating with your attorney.